Matikbebo, I bring you here at this point because for you, you have followed the work of the OSP right from the get-go. I'm talking about when Kisi Ejabeng took over as Special Prosecutor.
Yeah.
You haven't hidden your admiration for him, and that's just for open disclosure on this matter. But then again, if you take a look at what has happened over time. In fact, I recall that in the case of Cecilia Dapa, there was one error that he made, which led to the court throwing out an application, in fact, granting an application against him, that you described that error as very elementary. One procedural error that if you're asking the judge to grant you that application to freeze the accounts of Cecilia Dapa, and you are failing to tell the judge the details of that account, how do you expect the judge to give you that? That's you described it as basic, elementary, procedural, error that he shouldn't have committed, right? And then we see it play out in this Charles Edubuain case as well, which you disagreed with him as well. Granted that there are elements in the judiciary in there, is it wholly the case that Kisi Ejabeng has been treated unfairly?
That's the question that, or let's say, the answer has to be nuanced. So we have to give the various shades of it. Yes, if as soon as you say, has he been treated unfairly, I'll say yes when it comes to President Kufuor, because that one is easy and is verifiable. Because when it comes to the office, as we sit here, Kufuor still hasn't given Kisi Ejabeng the establishment budget. And when we talk about the establishment budget, even from the name establishment, that's the budget to establish the office properly. It's not been given. So he needs quite serious and modern infrastructure to fight corruption. That has not been given. The last half-yearly report he gave, so it's a matter of public knowledge. It's in the report where he mentioned that, listen, they still haven't given him the establishment budget. And it was on the back of it that we gathered 100 signatures. And just when we were about submitting, there was this 249 that they employed. So I thought, then that meant that the establishment budget will come in no time. But it's been 3 months, it's not been done. And so we'll go ahead and even submit it, right? Yes, so when you ask that, has he been treated fairly? As I said, we'll give a nuanced answer. When it comes to the executive, absolutely not, because he's being starved, right? Yes. Now, then the next part, and I'm sure that's what you'll be most interested in. The judiciary, that one, it's a very complex matter. Like you said, you've referred to the first, not one of the cases in talking about trying to get a freezing order from the court in respect of the accounts, and where I thought that, look, if I was a judge, there was no way I was going to grant that application because the application didn't have enough meat. It didn't have enough details.
That's in the Cecilia Dapa case.
Cecilia Dapa's case, yes. So you see that part, it's not easy for me to jump on the bandwagon and say the court is not being fair to him. We can't lump the cases together. We have to do one by one analysis. And then let me also mention this. You see, Mr. Kansi, I make my living in the courts. That's why I can come and sit here and talk freely. You see, yes, that's where I make my living. So if I have to talk about the court, I have to be very objective because Monday morning I'll be in court. Yes, that's 5 days a week. That is where I make a living. So when it comes to the court, I have to be, very objective. Okay, yes, very, very objective. And even sometimes even lean in favor of the court a bit because, Charlie, you can't...
Without also relegating the realities or the fact of the situation.
Exactly. That's why I said we'll take it case by case basis. So you see the Cecilia Dapa matter. Let's even go back a bit and say, so the Cecilia Dapa matter we spoke about, there were 2 applications conjoined in one. There was a seizure of the extra, let me call the second tranche of money that Mr. Ejabeng found. That's the $590,000 and then the 2.8 million cedis. So he went to get a confirmation order for that, and the judge said no, it was beyond the 7 days. So you see that one, I was clear that, no, that one I disagreed with the judge because I thought that 7 days, the judge could have still granted the order because it's not every timeline in the law that we keep. Yes, well, you ask lawyers, they'll tell you it's not every timeline. There are a number of things, not to go into details, but there are a number of procedural matters in court that we don't, even though there are timelines, we don't strictly keep because it's impossible, it's humanly impossible. So there are some that our jurisprudence have shown that, well, this particular timeline, when you don't go by it, we can, an exception is being made because you hear to every rule there's an exception. So simply, let me just mention to put it in context. When you go to court and you file your appearance, when it comes to filing your defense, most of the court levels is 2 weeks. Like in the circuit court, high court, you have to file your defense within 2 weeks, 14 days. If you don't file within and you go beyond, sometimes even months, several months down the line, once the other party hasn't taken a step of obtaining judgment against you, anytime that you send it before that time, it's accepted. When it comes to judgments that the courts also deliver, yes, there are rules for 8 weeks and all that. But the Supreme Court is held that if the judge doesn't bring the judgment within that time, and that's if the judgment is given later than the stipulated time, it doesn't make the judgment void. You hear ex parte, this in EPP, expandable polytrain, blah, blah, it's a long name. Okay, those are just 2 examples. There are other examples. So based upon it, I was thinking that if I was the judge, the 7 days that Kissie Jabin didn't adhere to, I would have covered it and said, look, the seizure, and confirmed the seizure of the $590,000 and the 2.8 million, right? So you see that in that decision, one of it I was with the judge, the other one I was not, right? So we'll do case by case, right? So the point is to say that I cannot just blindly say that the judiciary has been unfair. We have to do case by case. Now, the other cases, you see, this is a press conference. In order for me to be able to follow, you have to put out so much details for the analysis on each one. So you see this Madam Dapa one, we got as many facts as possible. So you see that we are able to analyze. The other ones, they are short statements. Hey, I can't just go with Mr. Jabin on it, especially as we've shown that he himself, the one we showed the confirmation of the freezing of the accounts, I disagreed with it because he didn't do it the way I thought it should have been done. So the point I'm making is that these other cases is mentioned because it's not put up enough facts. It's not easy for me to go with him because for me to go with him, I must also assess, knowing very well that Mr. Jabin is a human being. He won't get it. He will not always get it right? Mr. Jabin is a human being. So in order for me to go with him, I had to get as much details as possible about those other cases. And in this particular case, the presser didn't have enough details, so I can't just run with
the press conference didn't give enough details?
Yes, for me to go with him on the other ones. So on that score, I have to reserve judgment, except to say that you know that I support his office. And of course, the other things he said, that generally, and Professor Entry has mentioned it, we are not supporting him enough. Not enough lawyers are supporting. It appears we are rather happy to support President Kufuor, who has been shown to be very corrupt. You see, and so he's starving Mr. Jabin. Kufuor is making all the money. And Kennedy Japan, thank you, Kennedy Japan. God bless you for exposing the Kufuor and the rest of the government. You've said it clearly. Oh yeah, that's why he's doing. But not giving the establishment budget. What do you think? Because the establishment budget, if he had it, he said Jabin will be able to watch. I mean, the cyber, a lot of modern gadgets that he wants. Forensic, so that he can, fight harder. Why would the Kufuor arm his opponent? Kissie Jabin is an anti-corruption, his agency is an anti-corruption institution. So if he finances or, equips it very well, it means that the fight on corruption is going to be increased several notches higher. And the Kufuor will be hot. Don't forget the Manasseh, the fumigation he did, which he personally authorized and which will hold him accountable for. All those matters are still there. Yeah, he'll be answering for them. I can't wait for January 2025. Yeah, Kufuor will be answering for those corruption things. The ones that he personally supervised. We lost over 500 million when the Kufuor himself personally said they should do fumigation when they were already contracts and the rest. That's the story Manasseh did and won the last award, the West Africa Journalists Association. Yeah, so you see that the international community looked at it and they thought that President Kufuor was corrupt in that instance.
When this matter came up, the Special Prosecutor himself, in fact, you recall that when Martin Armido was in office, right, he raised concerns about these similar cases of being starved of resources and so on.
Yeah.
and then you hear this same special prosecutor come out as well. In this instance, his frustration is not wholly with the executive. He's talking about the judiciary.
Yes, so yes, so Mr. Counsel, that's why I've said, so we have to do case by case. And unfortunately, not enough details were given for me to do case by case. But of course, I'll repeat that overall. And let's not forget, if all these cases is mentioned, if he had won, I would have celebrated. Of course, because we all want to fight corruption. And because we know that the way Akufo-Addo is corrupt, his government is so corrupt, and in Japan he said that they have what? They are stealing the money and stashing it abroad like there's no tomorrow. So I want to see more cases. But once those cases didn't go well for him, then it means that we have to analyze critically. And I said to analyze critically, I've not been equipped with enough facts on that. You see, because we have to be, and they even tell you there's the other side to it. Another side to it is that for every practitioner, all right? Mr. Counsel, let me mention this. As practitioners at the bar, there's one dominant thought. Yes, like the way we practice at the bar. One very dominant thought, and it's very key. So let viewers and listeners pay attention to it. The fact is that when you go to one court, that's the trial court, and you lose, usually we are not given to complaining too much until we've gone on appeal. So if the matter started in the High Court, go to the Court of Appeal. If you lose there, go to the Supreme Court. You say, yes. And then even within the Supreme Court, after the ordinary bench is given the decision, there's also what we call the review jurisdiction. So you apply for a review. Have you seen how Chachi Chikata fights his cases? Step, step, step. So the other side of it is that before I can talk authoritatively, apart from the fact that I don't have enough facts, those other cases, what has happened? Because let's mention Sir John. Sir John's own, after the decision, I thought there is an appeal pending. So as Mr. Jabin was complaining, what has he told us about the appeal in the Sir John matter? What has he told us about the appeal? And then the rest of the other cases, what has he done? So look, and that's what I'm telling you, if you ask majority of lawyers, this is what they will tell you, that have you exhausted the judicial avenues, the fora? Until you exhaust it, we can't throw our arms in the air. Prof, that's it. For us as practitioners, that's it. You go to High Court, you lose. Everybody will tell the master, go to Court of Appeal. Court of Appeal, you lose. They say, no. Go to the last point. Go to Supreme Court. After Supreme Court...
That's the frustration he's talking about, that they are frustrating.
But that is due process.
Does this amount to frustration, or it is due process that is...
Because, that's what I'm saying. I'm not in a position to go with Mr. Jabin because he's not, as I said, two reasons. One, he's not giving enough facts. And then two, he has not exhausted the appeal process. He should not forget that he himself, you see, today, he's pointing fingers at the judiciary. A few weeks ago, and today, we are still also pointing fingers at him when he let Edu Boahin go. He let Edu Boahin off, despite a clear law, off the hook.
Yes.
He let Edu Boahin off the hook. So, Mr. Jabin, you see how it is? Today, you are pointing hands at the judiciary. They are frustrating you. You got Edu Boahin. This is an open and shut case. Open and shut. You heard Professor Entry, who is also supporting here, and I'm your ardent supporter, supporting you to a fault. Yet you let Edu Boahin off. You think we'll forget that one. So that's how it plays out. You are pointing fingers at the judiciary. You have let Edu Boahin off. Even people who are not lawyers all saw that, look, this Edu Boahin matter is classical corruption. That is what we call a textbook example of corruption. Mr. Jabi, you are telling us Ghanaians that for you, you didn't see influence peddling. Meanwhile, influence peddling is all there for you to see in section 252 of Act 29. How can we do that? So you see, because you also have your frailties, it's difficult to just run with you and so that I will just also lambast the court when I've not seen enough facts. So you have to come again. That side there, you have to come again. You see? If maybe, but of course, we have to give you some slack because you are in there. Maybe there are a lot, and naturally, there are a lot of things that you see that we don't see. But that is not on the 4 cases because, yes, I heard you, and you see, for Mr. Jabin to say that, hey, there is danger looming, meaning that there's more corruption, more. You heard, Mr. Okanse, can you read that part? It tells you there are still more. And we also know it's not every case that we hear publicly. But privately, we've heard of other cases that have come to your office and the way things are done, the way there's pressure and all that, right? Yeah, so those ones will support you. But it's not everything we can support. I can't support you against the court when I don't have all the facts. The ones I have, I would come to a decision on them. But the ones you don't give enough facts or it's not possible for me to assess or within that space of time. Don't forget, as I said, I also make my living somewhere. We come to sit here, we sacrifice our private time to be able to help because we are all trying to build a democracy. So sometimes when you want to help the advocacy, you have to also gather all the facts and put them out there in the public. Then, based upon it, we can also help by reading and analyzing. Because now, if you say, oh, but we need to go to the court and check. To go and check where the, they said, what do you call it, say, John appeal is. It's a lot of work.
Well, that's the message from Sami Darko. I'm sure you know, lawyer Sami Darko, who works with the Office of Special Prosecutor. He says, in this case of Sir John, there's already a ruling. The ruling have steps the OSP took. Colonel Damois case.
So is there an appeal?
The details.
When we told there is an appeal, so what are you saying about it? You have to put out enough facts. Have you exhausted it? Yeah, please go ahead. You can read the rest.
Sami Darko is going to be joining us in a bit.
Yes.
But it says that in the Customs La Bianca case is out. How can that not be analyzed? Charles Bishu says it's been long out since June. Why the need for extra information when information is already in the public?
Where is that? So, look, let's ask simply. La Bianca. Yeah, La Bianca, we lauded this. Is La Bianca one of the cases? I thought we are talking about the court case. We praise Kise Jabin for the La Bianca one, right? We praised him. Now, when it comes to even the La Bianca, the judgment, you see what I'm saying? The thing is that, you see, something that when here now, we've spoken privately about some of this things. You see, that is his full job. For us here, this is part-time. If we can't call it part-time, I said, we are citizens helping.
It's a voluntary work.
Voluntary work. Yes. So the amount of time Sami Darko can spend going to gather all the information, I don't have that. I don't. I must make a living. So to make it easier, when you do, put out all the, when you say, what do you call it, the Damois matter, as I sit here, Mr. Okansi, have you seen the High Court judgment, the Damois matter?
I haven't.
I have not seen it. So how can I analyze? And besides, as I said, the dominant thought at the bar. So maybe what we can say is that as a lawyer, it's good Sami Darko himself is coming. So he can talk. From where he sits, he makes his living from OSP, right? So the extent to which he wants to go will be different from mine. Mine, I have to be circumspect because I'm in there. I work in the court 5 days a week. So certain things I cannot just support. He is a bit free, so maybe he can talk beyond even evidence before him. But I can't because I live in the court 5 days a week. So you must give me evidence. You must. So you see, so when he says the evidence is out there, where is the La Bianca judgment? I haven't seen it. So what am I going to say about the, when we say La Bianca, we mean this side, the Colonel Damois matter. Damois and Duchi who went to court. The judgment, we've not seen it. So how can I say anything about it? We can't comment just based on what the media have given us, not thoroughly. If there may be some, if you want, what do you call it, just a general comment, a cursory one, I'll say yes, it broke my heart when they lost. Yes, if that's the one, but I don't think that's just emotional sentiments that you want. I think you want a proper critical analysis.
Indeed.
As for Lucy, yeah, when they lost that case, it broke my heart because, you know, as we said now, when Mr. Jabin came out with the report and told GRA to come out with a policy to stem those advanced rulings, let's use the normal word, the discounts they were giving to their friends and family and friends business, GRA complied. The Commissioner General, Abishada, he did well. He complied, and they came out with a policy. And my understanding is that that new policy is being implemented, and so the loopholes, as much as possible, have been what? Patched or have been sealed, and so presumably we are making more money. Now, that La Bianca matter also, when he did it, based upon it, at least we've saved what? A lot of money. Even that particular case, we saved a few millions. So, Mr. Jabin, kudos. As for that one, we've supported you. It's where you say we should join in saying the courts are intentionally throwing out the cases. It's that particular one that, hey, I can't, no. If I were to do that, it will show that everything I've worked for, I've just thrown into the drain. I can't come to join that one because what you know, Mr. Jabin, I don't know. You have far more. So this is what we call information asymmetry. Asymmetry. So he has far more information than we have. So once there's that imbalance, what you have, I don't have, I can't go with you.
So give it out.
So give out everything, then we can analyze. But with this huge information asymmetry, I'll be committing suicide in just joining you. Then it's like, people, you don't even know what you're doing. Today you say this, tomorrow you do, you're all over the place. No, I have to be consistent. We comment based on facts. You see. So, but Mr. Jabe, as we also say, the appeals are important. Yes, it's good he's lamented, okay? It's also good to vent. Because they say men, often we don't like crying.
Yes.
And so because we don't like crying, things happen, and then before you discover the man is dead and all those things. So it's okay. Let him, lament. He's vented his spleen. It's okay. It's cathartic. Yeah, when people talk like that, you get healing. Now he said it. I'm sure lawyers too would have called him and told that, oh, no, what is happening to the appeals? Because that's the first thing every legal practitioner, one who practices in the court, that's the first thing you say, oh, but Master, these cases you've mentioned, are you on appeal? That's the first question any lawyer practicing. Practicing, that's the first thing you ask. Have you appealed? Where is the appeal? So he should have thrown light on the appeals as well. As for supporting, we'll continue to support him, but except that we also continue to criticize, especially the way he left Dubois off the hook. And it's not yet late. Mr. Jabin, please go back to the Dubois hinting. You made a mistake. We'll tell you 1,000 times. Section 252 is good enough to cover a Dubois hint. It says that where a person, gives consideration to another, that he should influence a third person. It's what? Influence peddling. Don't worry about the name. The main thing is that, do you see a sequence of 3 persons in section 252? It's clear. It shows somebody who is giving money to another person in the middle. So A gives money to B for B to be able to talk to C to get some favors in the public office.
And it happens.
And he himself, very good. And he himself even concluded that thing is influence peddling. Except that Mr. Jabin was saying that he doesn't see any law in the, Act 29, the Criminal Offences Act. And plurality of lawyers, we are telling you that it's 252. Even apart from 252, we've also shown 247, where he collected money. When Dubois, he took the money. On what basis? And all that. And even also there's a part that when Dubois brought in that money, $40,000, obviously he didn't declare. And I did a case. The Supreme Court held that when you come in with more than the Court of Appeal, just last month, it was one of the valedictory judgments of Justice Amagezi when she was retiring, the last judgment. They held that when you come in with money beyond the 10,000 threshold without disclosing, it involves an administrative penalty under the Customs Act 2015, right? Right. Yeah, so GRA, that's why I keep calling that GRA has to step in. Minimum, GRA has to take, that's impose penalties on a Dubois when he brought in the $40,000 without disclosing. And then number 2, for Mr. Jabin, look, let's go to court. You see, they say that he is saying he doesn't see the law. Today, Mr. Okanse, I'm largely sitting here because I took cases to court. Pebu number 1 versus Attorney General number 1. Pebu number 2 versus Attorney General number 2. Number 3, number 4, and so on and so forth. That's what brought me here. That is how come your predecessors brought me here, because they saw that, this young, especially the non-bailable, it became very popular, and then people thought that, oh, the one who did it, let's interview him. I think maybe the first few interviews went well, and that's how I got the seat here. So the point I'm making to Mr. Jabin is that where there is so much debate on the matter, you should have taken the matter to court. Test it. You can't get it all right. So this Dubois matter is not dead. I'm now researching. I've just bought some books. They just got delivered about 3 days ago on influence peddling. More. Want to research more. So that I will call upon the...
That is a very good thing.
Yeah, I've bought 2 books from...
We don't have professionals in this country who are reading all the time to update their knowledge.
Excellent.
We should begin that practice.
Yeah, I've bought 2 books. They just came from Canada and then the UK. Want to do more research and take this case to court. So Mr. Jabin will be fighting you on that one. You better recall the report on Dubois. Were you doing it for Baumia? Because it's curious. Let me ask that question. Why is it that the report was released a few days, a week to the
you answer
elections?
that question. That's what's his name? Samedako. But lawyer Xavier Koji is joining us on Zoom as well. He is the head of public affairs of the Ghana Bar Association. Lawyer Xavier Koji, can you hear me? Good morning.
Good morning, Alfred. How are you?
I'm well, thank you. Thank you for joining us this morning. The specific verdict of the special prosecutor is that the judiciary, at least based on the streak of cases that have gone against him, there's a grand scheme in his view to frustrate his pushing the effort to fight corruption in this country. Now, why do you say that he should have exhausted the legal process before resorting to the court of public opinion, when in his own conviction, he has seen enough to get him to that conclusion that the judiciary is not helping his cause.
Alfred, thank you for the opportunity, and thank you for good morning to your viewers. Good morning to Mr. Martin Pim. Alfred.
Morning, Senior. Morning. Good.
Morning, Martin. Alfred, let us not just make general statements. You see, we are beginning to treat the judiciary like the Ghana Police Service. They don't do anything good. We don't want to hear that. Look, he is a lawyer of high standing. All we're saying is that he may have his frustrations, but just as Martin was telling you, we have procedures we follow in court. We have a hierarchy of courts. So if you commence a case at the court, at the High Court, for instance, and a decision is delivered against you, if you are not happy, you appeal. When you appeal to the Court of Appeal, and you are still not happy, you go to the Supreme Court, to the extent that you may even invoke the review jurisdiction of the Supreme Court. If you get to that last end, then you can now say that, oh, the system has ganged up against me. Even that, me, Xavier Kuje, after I have tediously exhausted the legal process, I will not say that, because that is the terminal end. So all we're saying is that he may be frustrated. At the time of expression of the frustration is quite premature, because he ought to have exhausted the legal process. Then he will now say that he didn't get what he wanted. Can he tell us whether or not the Court of Appeal or the Supreme Court would have been in a position to reverse the decision of the High Court? He cannot tell us that, because he didn't go to those courts. So that's all he's saying. And it's dangerous for somebody like him to making this statement. This should be coming from lay people. Look, we are all supporting him. The Ghana Bar Association will be the last group of people to say that fighting corruption in this country is a bad thing. We will never say that. We will never say that. We are level-headed as professionals.
I see, but then there was that the underlying concern in there, which sort of tends to tie into the sentiments that people even expressed before Kessie Jabin came in. The confidence in the court itself. The reason why even people sort of align with him or try to give Kessie Jabin's lamentations or frustrations a certain modicum of consideration is because of the confidence in the courts in itself, which has been captured in a number of reports, the Afrobarometer survey around 9 and so on, about the dwindling confidence in the courts, the suspicion of the courts not giving out justice as is expected, the judiciary in the eyes of the people, at least continuously losing that confidence. That in itself presents a situation, a problem that when Kessie Jabin speaks this way, it only goes to the minds of people, confirm what has been the suspicion all the while. Does that not concern you?
Alfred, I will be the last person to say that the judiciary doesn't have problems, because it's a human institution. But let us be fair to them. There are laid down procedures for you to follow. Did you do that? If you had done that, I would have been convinced that, look, you had an issue. But here is a case where maybe you moved the first 2 steps. You did not conclude the process. Then you have jumped into a conclusion that they've ganged up against you. Alfred, look, let us be fair to them. They may have issues, but I think that we shouldn't jump into conclusion. I will urge everybody to have confidence in the judiciary, because that is our last line of defense. So we cannot just say that because there's a perception out there that there's corruption in the court system. So even if you commence a process, midway, you conclude that you are being ganged against. Meanwhile, you have the opportunity to continue up to the end. So you follow the process through to the end, and then you can be convinced, or you can convince somebody that, look, I've done all this as required by the processes and procedures, but still, I think that there's something wrong. Look, why is it that when the High Court gave a decision that Dr. Opuni's case must be started all over again. The AG didn't come to hold a press conference, but he went to the Court of Appeal, and the Court of Appeal said they did not agree with the High Court decision. This is the kind of thing some of us expect Mr. Jabin to be doing. We are all in support of what he's doing. A society which is have corruption gradually gaining ground or gradually getting institutionalized. Nobody would like such a society, because we are not saints, but some of us try to do the right thing. We let people know what we stand for wherever we go. That is why some of us, you can't even approach us with certain things. And I keep telling people that the judges themselves have questions to answer. If you know you are not a person of integrity, never dream of becoming a judge. Never apply, never take up the appointment, because you are acting in the stead of God as a judge. Because people couldn't solve problems. That is why they are in court, for you to assist them to solve problems. So Mr. Jabin may have his frustrations, but our point is that he is just playing a game that he ought not to have been playing at the time that he's doing it. Because if he had exhausted the process, as I said, I think his position would have been better appreciated.
But you see these frustrations that he's put out as a game he's playing. Why is that?
No, because he's creating a whole lot of, you see, many more people may put different interpretations on it. Is he ready to work? If he's ready to work, there are procedures to be followed. Follow them. And I made a point the last time that, look, public institutions such as this office may have powers, but in exercising such powers, they must also be mindful of the procedural steps that they must follow. Mind you, if people are accused of committing certain offenses, and you want to investigate and prosecute them, should need be, you must also follow procedure. The courts will never forgive you if you miss out on the procedures, because those people too have rights. So he's ready to work, we know, but he must do the right thing. We are all in support of the fight against corruption. I'm yet to know of somebody who will say that for him, he likes corruption. Because even if you're a beneficiary, one day, I have made this point before. Let's make this last point. Let me make this last point before he comes. I have made this point that maybe Martin Pebu will agree with me that our laws on corruption itself are facilitating the process. Why do you have a law that says that the giver and taker of a bribe, for instance, are equally guilty? We have a situation where no two persons who are in their right frame of mind will go and do a transaction that they know is unlawful and come back to public and say that, look, I went to give bribe to person A, so arrest me and go and arrest him. I don't think any person would do that. I think that under our special circumstances, the laws are made for us, we made the laws. So if we think that our circumstances are such that we need to change the law, I would suggest that we now make the law to say that it is the taker who is guilty, so that even if I'm sending you money, you don't know whether it's from me or somebody has sent me, so that we can get somewhere. Because I don't think that because the situation we have now is that the takers are taking, they are not reporting, or they are not causing the arrest of the givers. So let's change the trend.
I see. But you admit in that earlier submission that it is indeed the case that regardless of the low confidence in the judiciary, we certainly have no option than to go to the court, which is the case. But then you also concede that there are problems. And so people's sentiments are not born out of a vacuum. The concerns that people have expressed about the judiciary, the deficiencies in the judiciary, it's not in oblivion. They're talking about people's own experiences, personal experiences, or the experiences of people they know about the judiciary, which you say it's indeed the case that the judiciary has its own challenges. What is the GBA doing to also help show up the confidence in the judiciary so that, I mean, when Kisi Japi comes out like this, people would not wholly support him, but also take into consideration the specific instances that the judiciary has also not helped itself?
Alfred, I will say that some of the things we do as GBA is the interview I'm granting you now. You see, we must educate people to understand how the adjudication process works, so that they should know that if you start from stage 1, you have an option to move to stage 2 if you are not satisfied, up to the last end. The problem we have with this particular press conference by Mr. Ejebing is that he had not told any of us that he had exhausted the process. So it will create the impression to everybody that, well, if you go to court of first instance and they deliver a judgment against you, that is the end. But that shouldn't be the case. That is the concern we have. That is why I'm saying that we should be fair to the judiciary, because they have laid down procedures and steps to be followed. So let's be mindful of the steps, follow them duly, and then we can complain. That is our concern. So education of people as to how the adjudication process works is important, so that we don't even have situations where people will hold claps and go to a court that they are going to attack the court and the court staff because in the process of doing the case, the way cross-examination or evidence was being taken, they were not satisfied. That is not your issue. Wait for the court to come to a verdict, because no court delivers a verdict or a judgment or a decision in a vacuum. They look at the facts based on the evidence, or take the evidence and apply the law and come to a conclusion. So if you don't wait up to that stage, how then do you come to a conclusion that it hadn't gone in your favor?
Well, Lawyer Xavier Kuji, stay with me, but thank you for this first point that you made. Sami Dakon is with the Office of Special Prosecutor. He is going to join us on Zoom briefly on this matter, and then we'll move to the next issue. But you see, Lawyer Masbebo, a number of the things that the Ghana Bar Association talks about ties into the issues that you raise. But then again, it also doesn't take away, as I indicated, the concerns that the people have about the judiciary, isn't it, in itself, about the confidence and so on. So you get people normally just siding with the special prosecutor because of the existing concerns about the judiciary, isn't it?
Yes, Mr. Okansi, let's put
briefly
this one in context. It's not only the judiciary. All the arms of government have the same problem. The Speaker of Parliament just referenced one of the newest surveys on this matter of trust, and that was the Sunday before last Sunday. He referenced, I don't know which institution, but he mentioned that survey said that judiciary got 8%, Parliament got 8%, right? And then, no, sorry, the judiciary got 10, Parliament got 8, and the presidency got what? 14%. So you see how it's very, very low. You know, this is the same presidency that the last year's transparency GII, when their survey came out, the presidency was seen to be the second most corrupt institution in Ghana. Second most corrupt. Yet in this survey, they even did better than the Parliament and the judiciary. The presidency got 14%. Okay, actually, yeah, the presidency, they said the president, 14%. So the point I'm making is that, listen, as for trust in the arms of government, it's all over. It's been low. And it's because of the general, outcomes, the outcomes we are getting. So it's not only the judiciary. So if citizens say no, they don't trust, it's difficult for me. We can do a bit to educate. And also, Mr. Kansi, this is very, very important. For us, we want to take it on a case-by-case basis. Case by case. Otherwise, like I've said, so today, as I'm sitting here, I'm the same person. And let me remind you, so anytime you see me here, the reason I can't just say the judiciary are frustrating him. I've done what? Table number 1, number 2, number 3, number 4.
And all those cases.
Many others. Look at even Domlevo. Then they say Akufo-Addo acted rogue. The Domlevo case, CDD, I did it. I took CDD and other 9 CSOs to court. Of course, people have said that the Supreme Court delayed. But eventually when it came, it was a big indictment against President Akufo-Addo. We won. So today it shows that Akufo-Addo was one person who sacked Domlevo when he saw that Domlevo was about to expose corruption against him, the Kroll and Associate, Akufo-Addo and Osafo Mafo, the Kroll and Associate case, and other cases. You remember just around that time too, the case of the 52.5 billion that we couldn't find. The Auditor General's report showed that we couldn't find 52.5 billion. And you know that 3 years on, Mr. Michael Flu is still chasing it, the former president of the Institute of Taxation. Yeah. He's still chasing it. The Auditor General's report is still not out. 52.5 billion.
And which year was this? This was in
2020.
2020.
2020. Yes, that was one of the reasons Domlevo was sacked. So fellow citizens, fellow Ghanaians, you see, you are seated. So the point I'm making is that Yet, when the matter went to court, the Supreme Court said Akufo-Addo was dead wrong. And it's not that Akufo-Addo didn't know. He was acting intentionally because the Mlevo had caught him.
You think so?
Yeah, it was obvious. It was obvious. It was very obvious. Look, international institutions had written to Ghana, the International Association of Auditors. Everybody told Akufo-Addo that, hey, this matter of asking the Mlevo to go on this long leave is unconstitutional. It's unconstitutional. It's unconstitutional. Yet, Akufo-Addo will not listen. Why? Because the Mlevo was about, he had even caught him. It was clear that they had stolen. That's how it looks. That's how, because things
So Samir Akon, so we'll get back to this. Samir Akon is joining us. Let's not lose him on Zoom. Samir, can you hear me? Samir Akon, can you hear me?
Yes, hello? I can hear you.
If you can put your video on, we are having a little.
No, you can't. You can't see my face. You can only.
Okay, that's fine. But you see, we've had a number of positions espoused by just Martin Pebu, by the Ghana Bar Association as well, make the point that exhaust all the legal processes before resorting to the court of public opinion when you disagree with the rulings of the court. And not just go on a press conference and say the judiciary, there's a grand scheme to frustrate your efforts as the Office of Special Prosecutor to fight corruption.
Yes, Alfred, thank you so much. First of all, one of the problems we have in this country is also how media portrays stories. It's a very big problem. If media does not appreciate a statement that is made by an office like the OSP, it becomes problematic how you also communicate to your audience, just like how you box it into OSP versus the judiciary. Yes, I think I have read about GBA. I'll come to that. As for GBA, they are unique and often their stands are quite interesting. So, and their stands can never be surprising or out of the blue. I will call them, how do I call it? I'll call them like a stone. They are always where they are. I heard Martin Pebu also make some statement. I'll come back to you. Martin, we love Martin. He makes, he likes fighting, his goodwill and all that. But we also do acknowledge that in many instances, he makes sweeping statements at people, organizations. And so we will come there and address that matter as well. But let's go to the substance of OSP. And that's why I said I will need a little bit of time because you've had, and that's one of the reasons I don't really want to do interviews via phone because you may not have adequate time as people who may be on the panel in studio. Now, the OSP, people must understand, it's not just a prosecutorial office. Often the misunderstanding is that the OSP is just a prosecutorial office. No. And we've had instances where we've even, and this is known, there was a program that was organized by Shraj where we had a number of Court of Appeal and High Court judges where there was a mini clash between myself and some of the justices over these matters. And their concern was that, why does the OSP issue statement after a ruling has been delivered? Why does the OSP do that? And what if the OSP does that? It pitches the OSP against the judiciary or it creates an impression that something is going wrong. And the explanation has been very simple. The OSP is an organization that all of us are trying to appreciate. It's one, a law enforcement agency, two, a prosecutorial office, three, asset recovery office, four, a prevention of corruption office. Now, if you want to know the duties of OSP under prevention of corruption, you must avert your mind to Regulation 31 of the OSP law. It tells the OSP to do so many things. One, it tells the OSP to even bring out names of people the OSP considers not fit to be in public office because OSP has information that they may be corrupt. Except that it doesn't give the OSP power to stop the appointer from appointing such persons. And how can the OSP do that? The OSP can do that after it's done some investigations on such persons. It also empowers the OSP, for instance, to publish detected acts of corruption, which means that if the OSP is able to do its investigation and notice that somebody might have engaged in corruption, you must give me a little time. I told you that, give me a little time. I know you are in a hurry.
Indeed. But you are going to the specific issue.
I'm proving to you a particular point that there's a lot of duty imposed on the OSP to prevent corruption. And there's a lot of duty imposed on the OSP to tell Ghanaians when things are not right and when things cause corruption to grow in the country. The press conference of the OSP, it's not about whether he should appeal, he cannot appeal, like the GBA man was suggesting. It's basic law. And who said that the OSP has not appealed some of the cases? But we are talking about interlocutory decisions that seeks to clock the OSP from doing its work. And I'll take the first case, as you said. Martin Pepu said we have to take case by case. And the reason why I sent you that information was because that the ruling on Sir John is all over. Any lawyer worth his salt would have read the ruling by now and come to a conclusion whether you agree or disagree. So we have sent one matter to the Court of Appeal to decide. Assuming the governor of the Bank of Ghana discovers that he has a terminal illness and the doctors give him 2 weeks within which he's going to die. So by some corrupt means, the governor pushes all the monies in our consolidated fund to his private account. And the 2 weeks doesn't even reach and the governor dies. Will the court tell Ghanaians that, oh, the governor died before OSP discovered that he might have engaged in corruption and so we should allow his estate, his family, to spend the money? Or the court will fashion out a way for Ghana to get back its consolidated fund? The point SP is making is that these interlocutory decisions that seeks to stop the OSP from either investigating somebody or either clothing somebody with immunity hampers the fight against corruption and emboldens people. It does not mean that the OSP cannot appeal or the OSP will not appeal. The OSP is duty bound to let the public, including the judiciary, including all the arms of government, know the things, because it says that we must take steps and show Ghanaians which the processes, procedures, manuals, culture, everything that hampers corruption. And so a presser by the OSP, it's not because he thinks that he cannot appeal. No, he's already talking and demonstrating to us the danger and the harm and the precedent you set and how it will prevent the body from doing an adequate job and emboldening people who engage in corruption to seek refuge under the law. What is the second case that Martin said? Charles Bisu. It's a very simple case. We all know that the law says that the law enforcement agency cannot detain you for more than 48 hours. And thanks to Martin Pebu, the 48-hour rule has been largely been working. So what it means is that if you are arrested, you are Fredo Council, you are suspected to have committed corruption, and you are arrested, you have 48 hours within which to get bail. Why does a suspect run to court and say, stop OSP from arresting me? And the court also, ex parte, without seeing anything from us, goes ahead and stop the OSP. The SP is pointing out to Ghanaians, if we are not careful, and a lot of corrupt persons get to know that this has been, in fact, as we speak now, Cecilia Dapa has also filed a human rights action in court, asking the court to stop the OSP from investigating him, and a perpetual injunction to stop the OSP from getting into the matter. It's just like the same action that Charles Bisu took. Charles Bisu fought about 5 different actions, all seeking to stop the OSP from investigating him and prosecuting him. And for almost 6 months, it is his right to do that. But OSP is trying to also say that if we are not careful and we allow this culture to fester, it's going to impede the fight against corruption. Maybe I can allow you to ask, because the other ones...
There's a specific case, in this specific case of Charles Edeboing, the reference that Lawyer Matibebo makes about your conclusion that whatever happened in this case, even though it amounts to influence peddling, there's no specific law that criminalizes that or describes that as corruption. He makes reference to Section 252.
It's a dead horse.
He makes reference to Section 252. I'm coming.
Yeah, let me help you.
Hold on a bit. He makes reference to Section 252.
I know what you're going to say.
And makes the point that you cannot make that conclusion without taking into consideration the provisions of this section and make it look as though nothing really wrong happened, and so you left him off the hook. That's the point about Charles Dubois.
Yeah, Charles Dubois, let me tell you, it's a dead horse. You see, when he was talking, he even made reference that we can even use Section 247 of Act 29. But the OSP has no power over Section 247 of Act 29. The OSP rather has power over 151, Section 151 of Act 29. So we'll tell Martin people, this is a very simple research. He can check it up, right? On the issue, look, the job of a prosecutor is not always to win cases. That's why I find the GBA stance very funny. It's funny because, of course, their job to always come and say we are protecting the judiciary. But Kwesi Ejaben, as he said, is not here to pitch the judiciary against the public. He's saying that even if it were academic exercises, he had the right to talk about the rulings. But this time, he carries a bigger burden. He's not a private legal practitioner. He is the special prosecutor of Ghana. Even when the Attorney General had issues with the Opuni case, he took steps to do other things and made people know his stance, that it was a wrong decision by the judge. In the end, things have happened. What Kwesi Ejaben is saying is that as a prosecutor, it is not about how many cases he has won. He can win even 100 cases. If after the 100 cases, corruption is still rife, he has failed. And it is his job to determine whether there is sufficient evidence to prosecute someone or whether his law allows him to prosecute someone. So let's take Mahama Yariga, for instance. Mm-hmm. He had been placed before court by the former special prosecutor for tax evasion, among other things. When Kwesi Ejaben took over and studied the file, he noticed that the OSP did not have sufficient evidence to prosecute him. He stopped the prosecution by filing a nolle prosequi, and it didn't go on. It does not mean that the other people, especially those who belong to the ruling party, were very angry, because for them, even if you think there's no sufficient evidence, keep the man as long as you can in court. Let him be going up and down, and he will learn lessons from it. But that is not the job of a prosecutor. In the same vein, like Martin Pegu and others, they think that, oh, you go and try 252 and put him there. At least going back, court and back and forth, you would have wasted his time and all that. Let me ask you, Alfred, if we did that to you, will you be happy? If the OSP did that to you, will you be happy? Police service, we have all been defense lawyers before. And police administration, I remember there's a particular case as a defense lawyer I was following. And I kept pointing to the police that the evidence does not support the charge and nothing going on. But they said, no, let me finish. It took 6 years of very poor boys, about 6 of them, to be in court till the court set them free. 6 good years. What is the point? That you are punishing them? We have said that Martin Pepu does not have the raw tape. Martin Pepu does not know the case as much as we know. He has not even seen the raw tape. He doesn't have access to the interview we had with Tiger IPI, the interview we had with all the persons involved. Tell me, where in the video did Charles Dubois say that he is collecting money to go and influence President Akufo-Addo? He's collecting money to go and influence Vice President. You say, you can inference from it. Where? If a person says that, I want to have a discussion with the presidency, and what can I do? And he says that, if you want to see them, I know the president is my uncle. I know this person is this, so you can go and see them. Does that mean that the person has said that he's going to influence them?
But you conclude that it is influence peddling.
But that conclusion that there is influence peddling. But then again,
and you want to study influence peddling. Please study it very well. When you are done,
but then again, you see, we are making. Thank you, Samina. Thank you for joining us.
So just conclude that
while we round up on this, yes.
Didn't OSP conclude that it is influence peddling?
Yes,
but that was
there
is no law.
So you see, it's the special prosecutor's own conclusion.
Yes, listen, Jabin, your own boss, Samina, listen, your own boss signed and said it is influence peddling, but that you cannot find law. That is what your report said. So what are you now saying? You are disagreeing with Kwesi Ejaben. You see, Samina, you see, you are not disagreeing with your boss. Please read the report. It says it clearly that this is influence peddling, but that there is no law. That is what your report said. Now you see, you want to just mix up the evidence. You see the thing. That's how come.
I've seen this kind of blame
Okay.
shifting
Yes.
and time. But Alfred, quickly,
In a
this
minute.
is what is done in US. They scrutinize judgment step by step and then case by case. So what I would say here is that when you see the special prosecutor coming out after every judgment to the public to state their opinion, there's nothing wrong with that. In law, that is allowed. That come out and say that this decision we don't agree, and then he talks about the doom ahead. That's fine. But then he should go beyond that to also to the appeal court to appeal, so that we can also exhaust all the the steps in the law. But there's nothing wrong also exhausting every step and then criticizing or really scrutinizing the judgment. I think that is fair.
Mr. Okansi, one last statement.
minute.
And then he mentioned 247. If OSP won't deal with 247, what do we do? The law says it should what? Collaborate with other institutions. The Cecilia Adapa matter. Didn't OSP say he's going to call in those who have the mandate over money laundering? That is
Yes,
to say,
even FBI.
FBI, and
Yes.
then what? Yoko. In Cecilia Adapa's case, didn't Mr. Jabin say he's bringing in other institutions? So they do buy him matter. What happened that you're saying that because you don't have jurisdiction over 247, then it's closed? Oh, please be consistent. Just be consistent. Listen,
Right.
you make a mistake because this matter won't
Okay.
die.
Right.
It won't die. And you see, the more you make us drag it, the more you lose. And the point we are making is that, especially where there is this contentious debate about whether it is 252 or it is not, I've told you that you test it in court. I am chief tester. And today you see how our jurisprudence has been moved forward because of things that are tested. If you check, relatively at the bar, I'm a young man.
Okay.
I met senior lawyers
Right.
who said, Pebu, this and have you read well? Have you understood this and what are you doing? These cases
Right.
you lose. Today, what have we seen? Our democracy is moved forward. The cases are won.
Okay. Lawyer Martin Pebble, thank you very much for joining us on this matter. In fact, we're going to move to the next. Lawyer Xavier Kuje, thank you for joining us on this matter. Really appreciate your time. Xavier Kuje is the Director of Public Affairs of the Ghana Bar Association. Also, Sami Dakon, who is a Director of Strategy Research and Communications Division of the Office of Special Prosecutor, also joining us briefly on this matter. We'll go for a quick break. When we are back, we will go into the National Media Commission and the Onua FM, Onua TV case. Stay with us. We'll be back shortly.